They not like you? Oh. I was running late. It's this towel. Nobody here. It's that towel right there. It's awful. Oh. I'm sorry. You're fine.
All right, Mr. Abraham, who's first?
Mr. Waldron's ready.
All right, this is cause number CR 24-39, State of Texas versus Ronald Jack Edwards. Mr. Waldron, I believe we're set for pretrial today. Go ahead.
Judge, we are set for pretrial. A couple of things bring the court's attention. One, Mr. Edwards was on federal supervised release. We had a hearing, I guess, some 3 or 4 months ago. And he received a 21-month sentence on his revocation there. He technically is in federal custody right now. For whatever reason, you guys are getting to keep it for the marshals for free. But we have that sentence that he's currently serving. The other thing, Judge, I want to let the court know, Brian Giral with the tag unit is handling cases involving Mr. Edwards. In fact, indicted him in Smith County on an engaging case. I talked with Mr. Giral this morning. He's telling me that this case potentially will be dismissed. But if we could reset this, pass this to the July 2nd docket, we should know more by then.
All right, State, do you want to be heard on this?
Your Honor, I had a moment to discuss this with Mr. Waldron earlier. I haven't seen Miss Curry yet to see if she has any input, so I don't have any information for the court.
So as far as you know, Mr. Hartwell, you're going forward with your state prosecution on something that's not connected to his federal charges?
That's the best of my understanding. Yes, Your Honor.
You agree with that, Mr. Waldron? Does,
Judge, the federal prosecution was several years ago. He was released on federal supervised release. This case was the basis for, part of the basis for the revocation. We actually pled true to other allegations. But yes, this is not related to a federal sentence.
all right, thank you. All right, court will set Mr. Edwards. Is there any pretrial issues other than what you've stated, Mr. Waldron? Is there any reason we can't put him on a docket call? Is there a discovery issue or anything related to this case?
Judge, the only thing, and I don't know if it would relate or not, but I have not received discovery on a Smith County case, which could be 4B or maybe tied up with this exact allegation. It may be a situation where he can only be prosecuted one of two places. So if we can set it for a pretrial, I'll get with Mr. Raw, see where we are on the Smith County discovery, and then July 2nd, we can let the court know.
All right, court sets Mr. Edwards for an additional pretrial on July 2nd. That'll be at 1:30.
Thank you, Judge.
Thank you, Mr. Waldron.
Your Honor, Mr. Lowe is ready with Mr. Lyons.
Okay.
Your Honor.
Good afternoon, Mr. Lowe. How are you, sir?
I'm fine.
Ms. Abraham, can you just because I want to look Mr. Lowe dead in the eyes, can you adjust that camera? He's unlike me, he's not vertically challenged. So, all right, there we go. All right, let me go ahead and call this case for the docket. This is CR 23-221, State of Texas versus Jonathan Lee Lyons. And I believe that we're set today on the ruling. I think the docket says motion to revoke, but that's not it. I believe it was on the status on the court's ruling on the motion to suppress. I'm assuming you've received the court's order denying the motion to suppress. Okay. So I guess at this point, we can either do one of two things. We can set up a docket call and decide whether or not there's any negotiations that are going to occur between the defendant and the state, or we can just go ahead and bypass that and place Mr. Lyons either on a bench trial docket or a jury trial docket.
So, Your Honor, I think I think our negotiations are at an impasse at this point in time. I wish that was not the case. I'm not really familiar what your docketing system is, but so we are going to request a jury trial in this case. So if you set it for a docket call, how does that work out?
Well, typically what I do is if I'm on docket call, I just give the time to the state and the defense to make any offers, counter offers, and determine whether or not a plea agreement is going to be reached. And if not, then at docket call, if the defendant rejects the offer, state rejects any counter offers, then I would place it on the jury selection docket. And the defendant would then, his case would be entered onto the docket. And once it worked its way up to the top 10, then you would be notified. So every month he would be on the trial docket, but you wouldn't be liable to be here unless it was in the top 10 for jury selection. So the reason I ask about and your comment on, negotiations are at an impasse. If you don't think it's going to be fruitful, then the quicker we put Mr. Lyons on the jury trial docket, the quicker he'll have his day in court.
Right. Here's my concern, Your Honor. So I've looked at discovery in this case. And what I don't want to have happen is we get 2 weeks out from a trial setting. And oh, by the way, we forgot to give this to the defendant to look at. So I would want some assurance at some point in time that, yeah, we finished our discovery. We're not going to add anything else. And then also, Your Honor, I did file a motion, ex parte motion. I don't know if you had a chance to look at that. So that would kind of help and make our decision where we were with that. So I guess for the time being, I guess the first option was docket. So you would put it on the docket, and then we could see where we are there. That would be my suggestion, Your Honor.
Okay. State. Yes, it does. Yeah. So basically it's just a docket call announcement. I'll give you 30 days and then the next 30 days, y'all decide what it is you want to do. And we'll come back to court and you can tell me and we can make sure that any offers that have been made will be put on the record. Any acceptance or rejection will be put on the record. And then we'll move forward like that. And I have seen your ex parte motion. I haven't ruled on it yet because I wanted to get through this hearing first to see if there was any announcement before I did that.
Right. And then I would have I know that the court has a standing order on discovery.
Correct.
But I need some assurance though, if we do something else, because if there's something else out there that I don't know about that makes a difference in negotiation, that's important for us to know. So at some point in time, and I don't know how you guys are running as far as jury trials. We said, yeah, we want a jury trial. We're probably looking at a year away or 6 months away, or that's an issue as well, Your Honor.
Sure.
He's already been here. He's been in jail now since September, so we're looking at 8 months.
Yes, he's not going to be specially set. However, I can give you, once I look at my jury trial cases, I can give you a rough estimate about when I think he would be in the top 10. But obviously, if cases start resolving or getting dismissed, which happens quite often, then that would speed things up. But I could give you a conservative estimate on when I think it would be, but I can't do that right at this moment.
So I guess we just put it on the docket and we'll look at it in 30 days and see where we are, Your Honor. Is that where we kind of
We can do that.
okay.
All right. How about we come back? Are you available on Tuesday, July 2nd?
I've got to be in pretrial in Judge Winter's court at 9 o'clock.
Oh, that day you will be? So you'll already be in Van Zandt?
I will.
Okay. Well, let's just set it on Tuesday, July 2nd. And then you can just bounce between the two courts and
Okay.
go ahead and do that. And so what I am looking for from your client is an announcement of whether plea agreement, bench trial, or jury trial. Mr. Lowe, you communicate with the state. Mr. Hartwell, I'm going to give you a chance to be heard in just a moment. But as far as getting the discovery, you could ask the state to produce their Michael Morton certificate of discovery so they can show you everything that they have in their file. That's one way of giving you that assurance that you seek on what evidence, are they going to bring. And obviously that, they could receive additional information and they have an ongoing duty to supplement and provide any type of, evidence that they're going to use against you, including mitigating and exculpatory. So, that's already built into the 3914 discovery. Mr. Hartwell, you want to be heard on this?
Mr. Lyon.
Yes, Your Honor. As for discovery, if Mr. Lowe would like to come down to the office and he can look at our file, make sure that everything is in the portal. Of course, if something new comes in from an agency or something like that, we upload it as soon as we can, as soon as we receive it. Sometimes that is, well after the final docket call. But usually when that happens, we're open to discussing resolving the case. But yeah, if Mr. Lowe would like to come and inspect our file to make sure we've shared everything that we have, then more than willing to do that.
All right, then we'll see Mr. Lyons back on Tuesday, July 2nd for docket call.
Thank you, Your Honor.
You're welcome. Make sure y'all fill out a reset slip, Mr. Lowe.
Right, Your Honor, do you see, we were supposed to have Henderson County and Mr. Lambert on Zoom for Joshua Davis?
I do see.
Mr. Lambert also?
No, Mr. Lambert, only Mr. Davis.
Also on Kenneth Taylor, CR 22-195.
Who represents Mr. Taylor?
Mr. Richard Smith.
Okay, go ahead.
He was not bench warranted from Russ County. They denied our request. He was to go to TDC today on their charge. So I guess in the future we'll have to bench warrant him from TDC.
Okay.
And at 2 o'clock we have an interpreter. If you see them, get on.
Okay, and that, who is that one for? Kevin, Jose?
Kevin, yes, sir.
Fuentes.
And Timothy Simpson is here. Kaufman County was nice enough to bring him over for us, this afternoon. I'm gonna see if Mr. Richard can get him so they can take him on back.
Okay, do you want to reach out to Mr. Lambert? Was he gonna zoom in? Hang on.
I sent him the Zoom, link.
Yeah, someone just entered. Let's see. No, it's Alfredo. All right, so you might want to touch base with him. Otherwise, Henderson County is going to be holding forever.
Otherwise, they're gonna bring it back. That's your problem. Cindy.
Hey, Mr. Schmidt.
Oh, sir.
All right, who would you like to go on first?
Timothy Simpson. Set for an arraignment.
All right, this is cause number CR 24-32, State of Texas versus Timothy Lane Simpson. You said set for arraignment. I show set for pretrial.
No, sir. It should be arraignment.
Sorry, he has multiple charges.
Yes.
That was a UUMV. This is also cause number CR 24-33, arraignment on forgery, and also CR 23-34, arraignment on possession of a controlled substance, state jail felony. Go ahead, Mr. Schmidt. I'm sorry.
Judge, I have received copies of the indictment. His name is correct. He understands the charges. We enter a plea of not guilty and waive formal reading of the indictments asked for a pretrial. So
All right, court finds that Mr. Simpson, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Cause number CR 24-33 and 34. Court now sets these matters for pretrial hearing on July 2nd, 2024 at 1:30. Court also sets Mr. Simpson's unauthorized use of motor vehicle for pretrial of even date.
And Judge, it's my understanding that Kaufman County has the ability to zoom inmates from their facility. We request that if the court will allow it, that Mr. Simpson be allowed to zoom his next hearing, as he won't be staying in our facility.
Is he going to be transferred to Henderson County or held in Henderson County?
It's,
You know.
is it Henderson or Kaufman?
Kaufman.
He's
sorry.
being held in Kaufman County, and we bench warranted in Kaufman County, will not honor the bench, but they did bring him today. So they're gonna take him back. He is being held here, yes, sir.
Oh, I thought you said Henderson County. Henderson
Sorry
County,
if I did, I'm not.
yeah, Henderson County does have the ability to zoom. Ms. Abraham, have we zoomed from Kaufman before?
We have a Kaufman County deputy here, and he acknowledged that they have that ability.
Okay, I have no problems with Mr. Simpson appearing via Zoom if so long as you and Mr. Simpson can communicate effectively and still appear separately.
I think we can, at least for the near future, and then after that, I'll make an announcement if that changes, Judge.
Okay, that's fine.
Mr. Lowe. So it's just me now? Let me do my research, and then I'll start working on it.
Now,
Who do you want next?
Charles Howard.
Charles Justin Howard, CR 2470 for arraignment, burglary of a habitation. Go ahead, Mr. Schmidt.
Judge, we understand the charges, received a copy of the indictment's name spelled correctly, wait for the reading and our plea not guilty. Ask for a pretrial service.
All right, court finds that Mr. Howard, having waived the formal requirements of arraignment, has entered a plea of not guilty. The court enters that into the record. The court sets Mr. Howard for pretrial hearing on July 2nd, 9 a.m. Dustin Blake Howard, cause number CR 23-218 for pretrial. Go ahead, Mr. Schmidt.
No contested pre-trial this time. I asked for Doug also, Mr. Howard.
All right, court places Mr. Howard on the July 2nd docket for docket call at 1:30.
Okay, that's all I'm ready on that. It's all day. There's two.
Your Honor,
Yes,
Mr. Lambert is getting on.
okay.
Yeah, he raised his hand. And that's what I would be sure.
I took that. Got mad.
should be it.
All right. Good afternoon, Mr. Davis. Let's
How
see.
you doing?
Doing fine, sir. Mr. Lambert is here too.
Right.
Mr. Lambert, can you see and hear me okay? You're gonna have to unmute that.
Yes, I can.
Okay. All right. Court calls, cause number CR 22372, State of Texas versus Joshua Lee Davis. I believe that we were set today for status on Mr. Davis's case regarding his federal custody. Let's see, where are my prosecutors at? Mr. Hartwell, are you here?
Yes, sir. Sorry about that.
All right. I'm looking for an announcement either from the state or the defendant on this. I think this was a 2022 case. I think it's been riding the docket. We have an announcement from either state or defense.
Your Honor, I apologize if you could give me just 1 minute. I think I just heard Miss Curry. I can go see if she has an announcement for the court.
Okay. Mr. Lambert, do you need to talk with your client at all? I can try to put you on a breakout room if y'all need to talk privately.
That would be great. I haven't talked to him in just a little bit. That would be fine. Yes, Your Honor.
All right. Mr. Davis, are you able to, you have a staff member there that will be able to put you, basically click on a button and put you into a breakout room so you can have a conversation just between you and Mr. Lambert?
I don't. I can call him back in here though.
All right. If you'll do that.
Okay.
Give me just a second. I'll set up a breakout room so y'all can sit and talk for just a second.
Okay.
Thank you, Your Honor.
Could you send somebody in here for the Zoom meeting again, please? They gotta put me in a breakout room or something.
All right, Mr. Lambert and Mr. Davis, once you see the invitation to join room 1, then just join that and it'll just be you two. And then you can leave that room whenever you're done and I can close it out.
Okay. They're coming. Here she comes. I need to join my lawyer in a breakout room. Just go to join.
There you go.
She said hers is coming up. She said.
All right, I'm gonna ask everybody to unmute.
Can you hear me?
Yes, sir. Okay, we're back on the record. Cause number CR 22-372, State of Texas versus Joshua Lee Davis. All right, any announcements from the state or the defense?
Your Honor, it doesn't appear that any negotiations have ever taken place. The state is ready to proceed to trial. There was quite a high amount of alleged controlled substance in this case, so we would be ready to proceed. I don't know that I've ever had the opportunity to speak with Mr. Lambert about this case at all. The last entry was that it was on warrant status.
Okay, Mr. Lambert.
Okay. Yes. Well, where the case was at our last hearing, which was, I think, 60 days ago, the client has been in federal custody for months and months and months and months and months. So he may have a warrant for failing to appear at his state hearings, but that's the reason why he wouldn't have appeared if he has a FTA warrant. With regards to his charges, I'm sorry, if I might. With regard to his federal charges or to his charges at all, I don't know why we're all garbled. Can you hear me okay?
Yes, sir. I can hear you.
Okay. With regards to the charges, what he's charged with in the federal court is exactly the same thing, the same transaction that he's charged with here in Van Zandt County. And so his federal prosecutor supposedly had spoken with the DA's office, and his federal defendant attorney, his appointed federal attorney, had spoken with the Van Zandt County District Attorney's office. And what was supposed to be happening was they've made him an offer that he's going to accept that is between 60 and 87 months. And the DA in Van Zandt County wanted him to actually be sentenced for that, for him, that to actually be a done deal. And then at that time, the Van Zandt district attorney said that they would go ahead and dismiss the case. I think that's a fairly typical practice. Judge Chris Wolf, who is the judge for the 213th District Court in Fort Worth, I think he's a former federal prosecutor or a former U.S. attorney. And I had a case like this about a year ago in his court. And because the charges were the same, it was the same transaction, it was basically the same charge. That is what he said is typical to do, and that's what we did in that guy's case.
Mr. Hernandez.
So, go ahead.
I just don't show any notes to reflect any of that type of agreement, Your Honor. We've discussed the case with Ms. Curry, who we asked to step out of a meeting, and she has no recollection of that either. So I would be happy to personally just follow through with this case and speak with Mr. Lambert if the court would indulge us in a quick 2-week turnaround, just to see if that really was the case, and
Sure.
hopefully put this case to rest.
All right, I'm gonna set it for a final docket call. And let's see. So Mr. Davis, so what you're saying, Mr. Lambert, is that Mr. Davis is in federal custody and he is anticipating taking a plea, but he's not done so yet.
That's right. And he has been anticipating taking this plea, he says, for, over 3 months.
A year and a half.
A year and a half. Okay.
Yes.
Anyway, I know that 60 days ago, your prosecutor, the ADA there in Van Zandt County, said exactly what I just said to the court, if the court may recall, that he had a deal in place, but they wanted him to actually have signed for it so that we knew exactly what it was. And so that was my recollection of what was done.
When is Mr. Davis's next federal hearing?
That I don't know, but I can find out.
We'll see.
It's not set, sir, for any, they haven't said it yet. And do I need to get my federal lawyer to contact y'all?
Well,
Certainly you need to call me.
yeah,
Okay.
Mr. Lambert needs to work with your federal attorney.
Okay.
What I was kind of expecting for this hearing is to know what it was that Mr. Davis was going to do, when he was going to court, if he was going to court. Because it doesn't, gentlemen, it doesn't do me any good to set this case for another hearing if if I'm setting it willy-nilly 30 days, 45 days, and Mr. Davis is not going back to federal court for a month, 2 months. I mean, I reset it for 2 months, and here we are. Nothing's changed.
Exactly.
No progress has occurred on the state side or the defense side. So the last 2 months has been a waste of time. So I don't want to set it for another 2 weeks, 2 months, a month. I mean, I'm going to have to, because obviously, I mean, the only other thing I can do is set it for trial, but it doesn't seem like either the state or the defense is ready for trial. So I'm going to set it for one final docket call hearing. And I need to know, we need some finality. This, either he's taking a plea federally and it's going to preempt a state prosecution, or he's not taking a plea federally. The feds are declining prosecution, the state's accepting prosecution. I don't even know if it's one of the same transaction. If it's not the same transaction, then you don't have those double jeopardy issues. So these are legal issues that need to be tied down and need to be presented to the court by the next hearing, so that we all know what we're going to do and when we're going to do it and how we're going to do it.
Very well. If I could go into a breakout room with my again, I would start that process.
Well, I don't have time to send you into a breakout room now,
Very
so
well.
I'm going to reset the case, and you can drive over to Athens and see Mr. Davis in custody there. You probably get more done that way anyway. I'm going to reset this to Tuesday, July 2nd. That's more than 30 days for y'all to talk with one another and figure out what you're going to do. But come July 2nd, I want something different written on my docket other than status.
Yes, Your Honor.
All right.
And Your Honor, if I may just request that Mr. Lambert get in touch with me, I'd be happy to work with him as soon as possible. That way, if we need any paperwork, we can make those requests with a lot of time.
All right.
If you could send me an email to a good attorney at Hotmail, then I'll have your contact information.
All right, Mr. Davis, we'll see you back on July 2nd.
Thank you.
All right, you're welcome. You have a good day. All right, Ms. Abraham, are y'all ready in the jail court?
We are ready.
All right, who are we ready on, Mr. Schmidt?
Jeffrey Mills.
And Ms. Abraham, Leonard Prowlis just entered into the waiting room for our 2:30 plea. Do we want to bump Mr. Schmidt for a second and do that?
He is Mr. Smith.
I thought you said Jeffrey Mills, though.
Are we talking about our interpreter?
Yes.
Yes, he's here and he's ready, so we can do him right after.
Yes. Yeah, let's do that, and we'll recall Mr. Mills.
Oh, okay, let's see this one.
Oh, I got it. Double switch.
Let me bring Leonard in. Good afternoon, Leo.
Good afternoon, Judge.
How are you?
I'm doing fine. Yourself?
Doing great. Doing great. Leonard, do you already see the interpretation set up on your side? If not, I may have to redo it.
It is on, but you'll have to redo it to identify myself as the interpreter. Just click in it and then manage and then retype my name and then redo it.
All right, I'm in the English channel. you're just selecting Spanish on the laptop, not on that computer.
Correct.
Okay.
Sí. Sí.
Excellent. All right. Leo, if you will state your name and license number for the record. All right. If you'll raise your right hand, I'm going to place you under oath. Sir, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right. Thank you, sir. All right. This is cause number CR 15364, State of Texas versus Kevin Jose Garcia Fuentes. And I believe that we're set for docket call today. Any announcements, Mr. Schmidt?
Yes, sir. I've been in negotiations with Mr. Hartwell. We discussed resolutions on Mr. Garcia Fuentes' case. I've explained those to Mr. Garcia. We'd asked to set this for a plea / resolution on your July 2nd docket. Or
Yes.
actually, perhaps, do you have, what are your dates in June, Judge? Do you have dates at the early end of June?
Early end of June. I've got June 18th.
Let's do June 18th if we could.
And do you and the state already have a plea agreement solidified?
Well, we have the framework of a resolution. Yes, sir. I believe we can get it done. There were some questions that need to be asked and answered. I think we can relay that to Mr. Hartwell and get this knocked out.
All right, I'd rather just set it for docket call then if y'all don't have anything nailed down for sure. And then if he rejects it, then we'll just set it on the jury selection docket. If he does accept it, then great, we'll do a plea that day.
As you wish. And what was that date again, Judge?
June 18th.
Thank you.
All right, court sets Mr. Garcia Fuentes for docket call June 18th. And I'll look forward to hearing whether or not we have an agreement or a request for trial.
Yes, sir.
All right, Leo, I believe that's all that we had on this afternoon's docket. Hey, great to see you. I was at a conference recently, saw a good video that was put together that had you in there. It was good to see. I believe it was. Yeah. Yeah, you need to get some royalties on that video. Have a good day. See you. Mr. Schmidt, who are we ready on next?
Jeffrey Mills.
All right, Mr. Mills, come on back up, sir. Sorry to bump you out of that spot just a moment ago. This is cause number CR 21229, State versus Jeffrey Alden Mills. And we're set for pretrial. Go ahead, Mr. Schmidt.
Judge, we do have no contested pretrial. We're prepared to plea. I think we still are. We have an agreement with the state. There are some critical errors, I think, with the paperwork that need to be adjusted. And Mr. Mills deserves some additional explanation. So we'd ask to set him for a plea again on June 18th, I guess would be a good day.
All right, court sets Mr. Mills for plea June 18th at 1:30.
Andrew Matkin.
Andrew Casey Matkin, CR 2426 for pretrial. Go ahead.
No contested pretrial, Judge. Asked for a docket call on that July 2nd docket.
All right, court sets Mr. Matkin for docket call July 2nd at 1:30. And that will be in cause number CR 2426 and also CR 2425.
Jason Williams.
Jason Rashad Williams, CR 23248. Go ahead, Mr. Schmidt. Docket call.
Yeah, that's correct, Judge. We're announcing ready for trial. We'd ask for a special setting on Mr. Williams case.
All right, is the state ready for specially set trial?
Yes, Your Honor, state will be ready for trial.
Okay, and Mr. Hartwell, can you put on the record what offers, if any, were made to Mr. Williams that are being rejected?
Yes, Your Honor, give me just a moment to look in the file.
I can.
Go ahead, Mr. Smith.
Judge, Mrs. Curry attended an offer of 40 years TDC on the indicted charge.
All right, and your client understands the court's policy not to allow plea negotiation between the state and the defense after an announcement of ready and a request for a trial?
He understands.
Okay. Ms. Abraham,
Yes, Your Honor.
you and I were just discussing our special set calendar the other day.
There's one that is going to be a plea soon. The state told me that.
Is that
And
Mr. Fulbright? Or is that something different? No, that's a rolling.
No.
Oh, I see.
yes, Fulbright is a plea,
Yes.
and so
18.
is
David Dixon.
David Dixon. Yes, sir.
That's correct.
And we had just set Dixon, especially.
All right, so it looks like,
Why would we special set Dixon?
We're not when we specially set.
Because Dixon is just a state jail felony.
because he was one of the few that were in custody, and so I have to give priority for those that are in custody over those who are on bail. Let's see, so that setting was in November, that was November 18th of 24. The only concern that I see is that Leonard Williams especially set November 4th. So it gives you a week between trials.
That would be a problem for me, Judge.
The only other thing that we may be able to do is Mr. Manning especially set with Mark Del Cambry in December. We may be able to flip those two, put Mr. Manning in November and give Mr. Schmidt December 9th.
Works for me.
I'm thinking that's what we do, Ms. Abraham. Do you know of any reason we shouldn't do that?
No, sir.
All right, then the court specially sets Mr. Jason Rashad Williams for jury trial beginning December 9th, 2024. Ms. Abraham, let's just remember to notify Mr. Manning of that change.
Yes, sir.
All right, who's next?
This is Nikki Etheridge.
Nikki Lynn Etheridge, CR 2471 for arraignment. Go ahead, Mr. Schmidt.
Judge, we received the indictment. She understands the charges against her. Name spelled correctly. We waive formal reading, enter a plea of not guilty, ask for a pretrial date. I guess July 2nd would be good for me.
All right, the court finding that Ms. Etheridge has waived the formal requirements of arraignment. The court sets this matter for pretrial hearing July 2nd at 1:30.
Marshall.
You say Marshall?
Marshall Parker.
Marshall Deshaun Parker, CR 2331. Is this a plea or not?
Oh, we're announcing that we're setting it for a plea, Judge.
Okay.
On that not July, but the June 18th docket.
Was there an issue with the paperwork today?
No, it was a communication issue on my side, Judge, with Mr. Parker. There were some things that I didn't adequately explain to him, but it is a plea for TDC time, so I'd ask for a little additional time.
And you said June 18th?
That should be sufficient, Judge.
All right, court sets Mr. Parker to plea before the court June 18th at 1:30.
Michael Whitten.
Michael Joseph Whitten, CR 24-9. Go ahead, Mr. Schmidt.
This is a plea, Judge.
All right, Mr. Whitten, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God, under the penalty of perjury?
Yes, Your Honor.
Thank you, sir. You can lower your hand. Make sure you speak up loudly and clearly. Your name is Michael Joseph Whitten, is that correct?
Sir.
And Mr. Whitten, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Do you understand everything that you've read and signed in your plea agreement?
Yes.
And where you signed, that is your true and correct signature, and you only signed once you were satisfied you understood what you were signing. Is that correct?
Yes.
All right, Mr. Schmidt, do you believe Mr. Whitten to be competent? And if so, have you explained to him both the advantages and disadvantages of a deferred adjudication plea, and that he's entering into this plea intentionally, knowingly, and voluntarily?
Yes, on all accounts.
All right, Mr. Whitten, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon. Mr. Schmidt, you got that paperwork there?
I do.
You see the problem?
I do.
All right, we're going to need to get that fixed. So there cannot be a finding of true on the aggravated assault deadly weapon issue. Well, I mean, what is the enhancement paragraph? I don't have the indictment with me. Is that it?
Prior.
It's a prior?
Yeah, prior felony charge. It would actually raise this to a first-degree felony, 599 life based on the enhancement if found true.
All right. So if I find it true, I think I can still give him. Think through this for a second.
I think that the range of punishment will change. You can still give him deferred. There cannot be a deadly weapon finding.
Yeah, and there's not a deadly weapon finding.
No, that's correct. I think the enhancements are just, the state wants to lock that in for the purposes of range of punishment. I think that's acceptable.
So would the second degree felony then change to first degree?
Yes, sir, I believe it would.
All right, so we'll need to have the judgment to change the degree of offense. It needs to reflect first degree felony. Okay. All right, I see
And I
that.
did admonish him to that fact. It's just the paperwork is.
Okay, I'm gonna admonish him at this time. All right, Mr. Whitten, you're indicted with aggravated assault with a deadly weapon, a second degree felony offense, which carries a range of punishment of not less than 2 or more than 20 years in prison. Also, the state is alleging that you have committed prior acts, which, if found true, would elevate your punishment range and degree of offense to a first degree felony, which carries a higher range of punishment of not less than 5 years or less, not less than 5 years and not more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division, and a fine, if imposed, of not more than $10,000. Do you understand that full range of punishment?
Yes.
And the proposed plea agreement that the state's recommending is that the court review the evidence, not convict you, but place you on deferred adjudication for a period of 6 years with a $2,000 fine plus court costs, reimbursement fees. You understand that if the court approves that agreement today and places you on community supervision, If at any other time during that period you violate your conditions of community supervision, the state could file a motion to adjudicate your guilt. That means to convict you. They could ask the court to conduct a hearing and allow them to present evidence. And if they prove to the court that you have violated any of the conditions of your community supervision, the court could do several things, including convict you, revoke your community supervision, and assess your punishment anywhere between the minimum 5 years up to the maximum 99 years or life. You understand that?
Yes.
Okay. All right. Understanding all that, I'll ask you at this time, how do you plead to aggravated assault with a deadly weapon?
Guilty.
And how do you plead to the enhancement paragraph found in either the indictment or the state's notice of enhancement? Is that enhancement paragraph true or not true?
It's true.
All right. And Mr. Whitten, are you pleading guilty today to this crime because you did in fact commit this crime?
Yes.
And are you pleading true to the enhancement paragraph because what is alleged is in fact true?
Yes.
And Mr. Whitten, has anybody threatened, forced, or pressured you to plead guilty or true?
No.
All right, the court will accept the defendant's plea of guilt and plea of true at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No, sir.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
Your Honor, just that state is in compliance. Victim impact statement was mailed out, was not returned. I can tell the court, though, that the victim is supportive of the plea. Actually, probation was his preference. So victim is supportive in this plea.
All right, say that again. You said that, you said the victim impact statement went out, but it wasn't returned, but you've been in
Correct.
actual conversations with the victim in this case?
Yes, Your Honor.
Okay, thank you. Anything further from the defense?
No, sir.
All right, and I don't believe that I have a copy of the stipulation, so in just a moment, I'm going to ask Mr. Schmidt if you have it, if you'll just hold it up to the screen and let me read that.
Yes, sir.
Unless you want to recite it, I don't think you did.
I think, Ms. Grisham would prefer I did not. Is that legible?
Yes, sir, it is. Hold it just there, just a second. All right, thank you, Mr. Schmidt.
Yes, sir.
And tell me, the notice of enhancement paragraph, was that alleged in the indictment or a Brooks notice?
That was in the indictment, Your Honor.
It is in the indictment, okay. All right, then based on the evidence presented, the court finds that there is sufficient evidence to convict Mr. Whitten of this offense. Further, the court finds that the allegation alleged in the indictment regarding prior convictions that Mr. Whitten has pled true to is true. Court finds that to be true. Court finds that upon that finding, the defendant's degree of offense is a first-degree felony with an increased range of punishment to not less than 5 years or more than 99 years or life confinement. The court will follow the plea agreement and the recommendation of the state of Texas. The court hereby defers a finding of guilt, places Mr. Whitten on 6 years community supervision, and orders him to pay a $2,000 fine, $290 court cost, and $520 in reimbursement fees. Mr. Whitten, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted, and then the probation officers will give you more information about what's next. You're welcome.
Would.
Who is this, Mr. Schmidt?
Donnie Joe Main.
CR 23-236, State versus Donnie Joe Main. Is this a plea today as well, Mr. Schmidt?
Yes, sir.
All right, Mr. Main, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, I didn't hear it. I saw your mouth move.
I'm sorry, I do.
It's okay. Sometimes with the audio is bad. Thank you, sir. You can lower your. All right, thank you, Mr. Main. If you'll just speak up loudly and clearly for me.
Okay.
Sir, is your name Donnie Joe Main?
Yes, sir.
And Mr. Main, are you a United States citizen who reads, writes, and speaks English?
I am.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt and the work he's done?
I am.
You feel like you've had enough time to talk with him about the case and that you understand everything that you've read and signed in your plea agreement today?
Yes, sir.
And where your signature appears, did you only sign those documents once you were satisfied that you understood what you were signing?
Yes, sir.
All right. Mr. Schmidt, do you believe Mr. Main to be competent today? If so, have you explained to him his rights as they pertain to this case?
Yes, I am.
And do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Main, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. A state jail felony does have a range of punishment of not less than 6 months or more than 2 years confinement in prison and a fine not to exceed $10,000. I see that in your case, you are pleading to a lesser included offense. What's the lesser included offense?
Possession of controlled substance, penalty group 1, less than a gram, state jail felony.
And I'm sorry, Your Honor, he was indicted on a third-degree felony possession.
Okay, so your original charge was a third degree felony possession of controlled substance between 1 grams and 4 grams, which carried a higher range of punishment. But I see here that your lesser included is a state jail felony, which has the lesser range of punishment of minimum 6 months to maximum 2 years. And I see the plea agreement is that upon your plea of guilty, state's recommending that you be sentenced to 24 months confinement in state jail, and that you pay restitution of $180, court cost of $290, reimbursement fees of $20, that you would receive 250 days credit towards that 24-month sentence, and the state would be dismissing a possession of marijuana less than 2 ounces case. Is that your understanding of the plea agreement, Mr. Main?
Yes, sir.
All right, understanding all of that, then how do you plead to the lesser included offense of state jail felony possession of controlled substance, penalty group 1 less than 1 gram?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
I am.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court has the stipulation and review that. All right, and Mr. Schmidt, I believe in the stipulation of evidence, there might have been a typo. Did you change any second sentence? It says contacted my Trooper Sagnamine. I believe that should be contacted by Trooper Sagnamine. Do you see that? Second sentence, second word, my should be by, by.
Yeah, I see that. It should definitely be.
Okay, if you'll correct that, then based on the evidence presented, the court finds that there is sufficient evidence to convict the defendant. In this case, the court will follow the plea agreement. Court hereby convicts Donnie Joe Main of possession of a controlled substance in penalty group 1 less than 1 gram, a state jail felony. Court assesses punishment pursuant to the plea agreement at 24 months confinement in the state jail division of TDC. Orders him to pay $180 restitution, $290 court cost, $20 reimbursement fees. The court dismisses under section 1245 possession of marijuana less than 2 ounces, DA cause number 2023-1095. In addition, the court awards Mr. Main 250 days credit towards his sentence for the time that he's already spent in jail on this cause, Mr. Maine, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted. Good luck to you, sir.
Okay, thank you, Your Honor.
You're welcome. All right, is this Miss Kennedy?
It is, sir.
All right, court calls CR 2458, State of Texas versus Cayla Michelle Kennedy. Is Miss Kennedy a plea today?
Yes, sir.
All right, Miss Kennedy, ma'am, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand. Your name is Cayla Michelle Kennedy, is that correct?
Yes, sir.
And Miss Kennedy, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt and the work he's done?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and that you understand everything that you've read and signed in your plea agreement?
Yes.
And where you signed your plea agreement, you only signed once you were satisfied you understood what you were signing with your true and correct signature. Is that right?
Yes.
All right, Mr. Schmidt, do you believe Ms. Kennedy to be competent, that she understands her rights, and that she's entering into this plea intentionally, knowingly, and voluntarily?
Yes.
All right, Ms. Kennedy, I believe that you are charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1 between 4 grams to 200 grams. Go ahead, Mr. Schmidt.
Judge, she was charged by an indictment, manufacturing, delivery, controlled substance, penalty group 1, 4 to 200, for pleading to a lesser included possession.
All right, thank you. All right, so Ms. Kennedy, your plea today is to the lesser included offense with a reduced potential punishment range, a second-degree felony, possession of a controlled substance in penalty group 1 between 4 grams to 200 grams. That range of punishment for a second-degree felony is not less than 2 years or more than 20 years confinement in prison, and a fine, if imposed, not to exceed $10,000. I see the plea agreement in your case is that you would be pleading guilty to that lesser offense. The state's recommending that the court review the evidence but not convict you, place you on deferred community supervision for 7 years, order you to pay a $1,000 fine, restitution of $180, court cost of $290, and reimbursement fees of $535. In addition, you would be placed on the intensive supervision program at the beginning of your community supervision. And part of this plea agreement, the state is asking the court to dismiss 2 of their cases that are unfiled, possession of a actually both of them possession of controlled substance, one less than 1 gram, one between 4 grams to 200 grams. Is that your understanding of the plea agreement?
Yes, sir.
All right, Ms. Kennedy, to the lesser offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, less than 200 grams, a second-degree felony, how do you plead?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
The court accepts the court accepts Ms. Kennedy's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No, sir.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, sir.
All right, Mr. Schmidt, would you do me the honor of displaying that stipulation of evidence on the screen?
Yes, sir. 1 second.
Can you go back a little bit? It needs to focus a little more. Yeah, I can't get that in focus. Yeah, right there, just hold it right there. I think I can make it out. All right, thank you.
Yes, sir.
Court, having reviewed the stipulation of evidence, finds that there is sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. The court defers a finding of guilt, places Ms. Kennedy on 7 years community supervision on the second-degree felony offense of possession of a controlled substance. The court orders her to pay a $1,000 fine, $180 restitution, $290 in court cost, and $535 in reimbursement fees. Furthermore, the court orders her to be placed in the intensive supervision program at the beginning of her probationary period, as to be further directed by the department. And the court dismisses under section 1245 unfiled DA 2022-384, possession of controlled substance, and DA 2024-318, possession of a controlled substance. Ms. Kennedy, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over to be fingerprinted, and then the probation officers will tell you about what's next.
Thank you.
Judge, I think I have a rehearing left. If you'll give me just 1 minute.
Yes, sir. Yes, sir. Go ahead.
Your Honor.
Yes, ma'am.
We are ready to finish our last person.
All right. All right, this is written number WR 24-00027. J. Randall Harrison versus State of Texas. Do you want to call your client, Mr. Schmidt?
No, sir. I'd like to announce an agreement between myself and the state of Texas and Mr. Harrison. Ultimately, we've agreed to a PR bond each on the 2 misdemeanor charges and a cumulative total amount reduced to $25,000 cash or surety on the 3 felony charges. How that's distributed mathematically is beyond my capabilities as an attorney, but I'm sure the court has a calculator.
Sounds like you're wanting me to solve a math riddle.
Yes, sir, I do. It's a word problem.
All right, well, let me ask, I need to be advised of the some information on the defendant. I need, in order to satisfy what I have to do as a magistrate under the new bail laws, I need to hear about criminal history, whether I need to know the bail factors basically before I'm to do this, and then I've got to report all that in the public safety reporting system.
I blame the state of Texas for that, Judge, not you. I'll go and call my client and elicit that testimony.
All right, Mr. Harrison, sir, if you'll raise your right hand, I'm going to place you under oath. Mr. Harrison, you're being called for the limited purposes of bail hearing today. All right. Do you promise that the testimony you give today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thank you, sir. You can lower your hand. Go ahead, Mr. Schmidt.
State your name, your full first name for the record, please.
J. Randall Harrison
And Mr. Harrison, where's your residence located?
in Canton,
Do you know what the address is?
201 BZCR 4124.
How long have you lived at that residence?
Almost 4 years.
Do you own that
No,
home? Do you lease?
no.
Are you staying with somebody else there?
I was doing caretaking for an elderly lady, Jane Shields, and they paid me to do that.
Okay, and so if the judge grants the agreed bond reduction and you make bond, is that where it will stay?
Yeah.
And do you have access to transportation to and from court in the event you get indicted in this case?
I had a car there, a white Honda, but I don't know if it's still there.
But you live in Canton, you do realize that.
Oh, it's 3.8 miles, yes.
You'll be required to appear in court in person.
I'll buy another car.
Okay, so you can manage that. Now, currently your bonds are set cumulatively at $70,000. At $70,000, are you able to make those bonds?
At 70? No.
Yes, sir. And do you previously filled out an application for court appointed attorney where you filled out an affidavit of indemnity? You listed all your assets. Was that affidavit true and correct to the best of your knowledge?
Yes.
And since you filled out that affidavit, has any of the information changed?
No.
So the assets that you listed are the assets that you still maintain theoretically today?
I hope so. Yes.
You hope.
And Mr.
Well,
Schmidt,
I
I
have
don't-
squatters in my house.
I don't necessarily need to know the indigency stuff. I just need to know criminal history and whether it's the other bail factors, not whether I should reduce it, but I have to report to the state that I've reviewed his criminal history and that in doing so, I'm going to be lowering his bond. So really just focusing on criminal history.
Well, in that case, Judge, I would pass the witness and ask the state because they have access to that information and allow them to examine Mr. Harrison on that issue.
Mr. Hartwell.
Yes, Your Honor. And I'm sorry, I'm trying to pull up. I don't have much information on the new charges, Your Honor. I have a criminal history from about a year ago. If Your Honor would like me to print a fresh one, I can do that. To make sure that what I'm showing is accurate.
Well, I'll tell you what, there's no need to do that. I have access to it, but what I'll have to do is I'll have to do that on my own and then come back and issue a ruling later. So that's all right. What I'll do is I'll take the agreement under advisement and I'll issue a ruling upon reviewing the PSRS as required by the new bail statute. Okay, so that I'm correct, the agreement between, and the recommendation of the state is personal bonds on, or did you say PR bonds or personal bonds?
Personal recognizance, PR bonds, personal bonds,
Okay, well,
misdemeanors.
all right, so
I'm not sure
personal,
the distinction.
well, I think PR is personal recognizance, which is your word alone, and personal bonds is to a value that you're personally guaranteeing. So one has a numerical value, one doesn't, but either a personal bond or a PR bond on the misdemeanors, and then between the other three charges, possession of controlled substance, third degree, unlawful possession firearm by a felon, and tampering or fabricating physical evidence. The agreement and recommendation is a cumulative $25,000 split between those three.
Yes, sir.
Okay. Correct, Mr. Hartwell?
Yes, Your Honor. And if Mr. Schmidt has no objection, just to put the specific numbers on them, I would recommend a 5,000 on the tamper, fabricate, and then 10,000 each on the other two charges. Would be my recommendation, but
No objection to that, Judge.
Okay. All right. The court will take the agreement under advisement. I will review what I'm lawfully required to review, and then I will issue a written order.
Thank you, sir.
Thank you.
You're welcome. All right. Are there any other cases? And Mr. Schmidt, let me ask real quick before Mr. Harrison leaves. If I grant these, then there's going to be conditions of pretrial release. I'm not sure if he's already signed any or not, but if not, just let him know he'll need to sign before he leaves. Mr. Harrison, before you get out of custody at any time, you'll need to sign your conditions of pretrial release. And those are going to be conditions that you're going to have to comply with anytime that you're on bail for these charges, meaning that you had to report to a pretrial release officer, pay a reporting fee, be drug tested, can't commit new offenses, can't possess a weapon, things of that nature. And if you violate any of those, then the court could revoke your bail and put you back in jail. You understand? Okay. So before you leave, make sure you get your pretrial release conditions signed.
Thank you.
Thanks, sir. All right. I'm sorry, Ms. Abraham, anything else on this afternoon docket?
Not criminal.
All right. This concludes the court's criminal docket for this afternoon. The court will stand in recess for the remainder of its civil and family docket.
Thank you, sir.
Thank you, ma'am.